than 100 years ago by the British who were ruling India. So idea of the British in bringing this provision was to put down the natives being the Indian population, that they should not get together and try to overthrow the British government. So this was a colonial piece of legislation where the idea was that nobody should overthrow the imperial government by force, by violence. That was why this section was brought in. I think it has lost all significance because India is a sovereign, independent nation and there is no case of any overthrow with violence. The overthrow of a government in today's times can be by democratic means. And though the Supreme Court has upheld this judgment, upheld this provision in 1962 in Kedar's case, I think time has come to have a relook and probably the government will do well to repeal this section, failing which I think the court may even strike down the section. But all in all, I am very happy with the stance taken by the court and the stance taken by the government.
Well, that's the reaction now coming in on the Supreme Court's sedition order. That was Mukul Rohatgi, who says that this was a bold order. Remember, the Supreme Court has basically stayed the registration of the FIRs, ongoing probes and the coercive measures on the matter across the country until an appropriate forum of the government re-examines the colonial era penal law. Now, we're getting in some more reactions. Let's listen in.
Very well. Now, with the matter coming up to the court wanted to examine it, and now the government has, of course, said that it will re-examine it. But while a matter is under re-examination, whether it should be stayed or not is a very big moot point. Because ultimately it puts to naught a valid piece of legislation. Ultimately, if something is revised for whatever reasons, that's another matter. But generally the practice has not been as such. And I will, for example, let me talk to you about triple talaq. Now, when triple talaq was under consideration by the court, it is not as if the proceedings had been stayed or any action had been taken or any directions given. So normally it would be better for time to wait as far as the petition is concerned or the judgment is concerned or the issues concerned of the government reconsidering, because it will create so much confusion. You have matters which are pending. What will happen to those matters? What will happen to people who are in jail? What will happen to people who have bail? What will happen to cases where there is multiple charges of 124A and other charges? I mean, there will be chaos. So normally the traditional situation has been possibly not to consider passing any kind of orders or directions in the meantime. Finally, whatever happens, of course, it's another matter.
This is a good development on account of the fact that sedition is a painful relic of colonial past. It has no place in modern day democracy. And there has been a blatant misuse since 2014 of this law to book people who primarily are indulging in criticism of government policies.
We have made our position very clear, and we also informed the Honourable Court about the intention of the Honourable Prime Minister. Beyond that, if anything else have happened, I don't know. But one thing I must say is that we respect the court, we respect the independence of the court, but there are things which is called Lakshman Rekha. All the organs of the state must respect each other and also to practice our respect in letter and spirit. Whatever we say, whatever we do, we have to ensure that we respect the provisions of the Constitution of India as well as all the existing laws.
ठीक है, सुप्रीम कोर्ट जो हाईएस्ट कोर्ट ऑफ द कंट्री है, उन्होंने अगर स्टे दिया है तो हम उसका वेलकम करते हैं और उम्मीद रखते हैं कि गवर्नमेंट इस पे सोच विचार करेगी और इस किस्म के जो भी कानून हैं जो लोगों की परेशानियां बनती हैं, जो लोगों को परेशान कौन करते हैं, उनको ख़त्म करना चाहिए। यही हमारी अपील है। आज भी हम यही अपील करते हैं कि इस मुल्क के अंदर ऐसे कानून हैं जो लोगों को परेशान कर रहे थे। कोई मतलब मकसद नहीं है जिनका, लेकिन कानून चल रहे हैं। इस किस्म के कानून जो हैं वो स्ट्रक डाउन होने चाहिए, ख़त्म होने चाहिए।
मैं समझता हूँ कि बहुत अच्छी मूव है सरकार द्वारा। सेडिशन लॉ का कोई औचित्य नहीं है एक आज़ाद देश में, और जिस तरह का उसका दुरुपयोग हुआ है पिछले महीनों में, पिछले कुछ चंद सालों में, उसके तो क्या ही कहना। हम सारी दुनिया में एक हास्यप्रद देश साबित हो चुके हैं। मेरा ये मानना है कि इतने ड्रैकोनियन और इतने कड़े जो कानून होते हैं, जो अंग्रेज़ों के वक़्त में इसलिए बनाए गए थे कि हमारी फ्रीडम मूवमेंट को सप्रेस किया जाए, ऐसे कानूनों को रिपील करना अति आवश्यक है। ये हमारे संविधान की रूह के मुताबिक भी होगा और जो भारत की अंतर्राष्ट्रीय ऑब्लिगेशंस हैं उसके अनुकूल भी होगा।
We must note that the government of Prime Minister Modi, in an affidavit, had told the Honorable Supreme Court that it wishes to re-examine this issue of the sedition provision in the Indian Penal Code. That itself was a very positive move. It must be noted in context of the 75th year of India's independence. It must be noted in context of Prime Minister Modi's government removing some 1500 obsolete or old archaic laws, and the fact that the government is committed for the welfare and for the benefit of every Indian citizen. In that context, when the matter came up before the Honorable Supreme Court, the Honorable Court, and it has been pleased to observe and accept that point that the government is going to examine the issue, and in the interim it has also asked the state governments not to file any fresh FIRs and keep the pending ones on hold, which is also the correct legal position, because after all, law and order is a state subject and the FIRs are registered by state governments or the state police. So we need to view it in the larger context of a positive development in line of the government's affidavit and Prime Minister Modi's government to look at it totally, and the Honorable Supreme Court accepting that point of view and therefore giving this direction.
जब से भारतीय जनता पार्टी की सरकार बनी है, अपने पॉलिटिकल लोग